Who appoints the judges who interpret our constitution, protect our rights, and sometimes even question the government itself? Is it the president, the prime minister, or someone else entirely? The answer isn't just a list of names, it's a story of power, independence, and constitutional interpretation. Judges play a vital role in India's democracy. Their appointment process shapes not just the judiciary, but also the relationship between the courts and the government. From the Supreme Court to the district courts, how judges are appointed reflects how much independence and accountability we expect from our justice system. Under Article 124 of the Constitution, judges of the Supreme Court are appointed by the President of India after consultation with such judges of the Supreme Court and High Courts as the President may deem necessary. Over time, this consultation clause has been interpreted through a series of landmark cases. The S.P. Gupta case, known as the first judge's case, held that the executive had primacy in judicial appointments, and that consultation did not mean concurrence. Supreme Court Advocates on Record Association case, also known as the second judge's case, overturned this, establishing that the Chief Justice of India's opinion, formed with a group of senior judges, would have primacy. The In Re Presidential Reference case, also known as the third judge's case, clarified the Collegium system, defining it as the Chief Justice of India plus the four senior-most judges of the Supreme Court. Today, the Supreme Court Collegium recommends names to the Union Law Ministry, and the President, acting on the aid and advice of the Council of Ministers, formalizes the appointment. Article 217 governs the appointment of High Court judges. They are appointed by the President in consultation with the Chief Justice of India, the Governor of the respective state, and the Chief Justice of the High Court concerned. Each High Court has its own collegium, typically comprising the Chief Justice and two senior-most judges. These recommendations are then reviewed by the Supreme Court Collegium before the final appointment is made. Chief Justices of High Courts are usually appointed by transferring senior judges from other High Courts based on recommendations of the Supreme Court Collegium. In 2014, the Parliament passed the 99th Constitutional Amendment, creating the National Judicial Appointments Commission, or the NJAC. The NJAC proposed a new system where both judicial and non-judicial members, including the Law Minister and two eminent persons, would participate in the appointments process. In the Supreme Court Advocates on Record Association case 2015, the Supreme Court struck down the NJAC as unconstitutional. The court held that the law violated the principle of judicial independence as part of the basic structure of the Constitution. The decision was met with both support and criticism. Supporters of NJAC argued it introduced transparency and accountability, while critics felt it diluted judicial autonomy. As a result, the collegium system continues to operate today, though debates about reforming the process are ongoing. What system do you think best preserves both fairness and transparency in judicial appointments? Share your thoughts in the comments, like the video if you found this helpful, and subscribe for more clear explanations of complex legal ideas.